Be the One to Execute Your Trust by David Robinson. The American Dream. March 9th, 1933, a day that will go down in infamy, spoken by Franklin Roosevelt on a different day, but applying more surely to this day too, for on this day, by the Trading with the Enemies Act and the declaration by Congress of the bankruptcy of the United States, a corporation, the American dream became a nightmare instead. Slowly but surely, the bankers proceeded to take over the federal court system, the taking over of which is now complete. For federal rules must now be used in state courts. Congress, never having lawfully assembled after Abraham Lincoln dissolved Congress when the Southern states walked out during a debate over the Civil War, nor ever having been passed into positive law, is now seated outside of the Constitution, as the court system is as well. This is the reason for registering to vote. For by registering, you were given the privilege of voting. And anyone who signs in and votes in the federal elections or in any election is voting as a corporate entity, a straw man, and is agreeing to the presumption that Congress has the authority to act from its foreign jurisdiction. The entire court system is now ruled by and under their foreign jurisdiction flag, which has a gold fringe around the edge and a golden eagle or gold symbol above the flag. And some courts will make a mockery of the United States flag by positioning it in a vertically gathered way rather than set free. The powers that be knew that all commerce is ruled by the law of contracts, better known as the UCC. No contract, no case. The schools began to teach that any contract you signed is a valid contract that you must fulfill. This saying is true as long as the contract is between two living souls where the contract is fully disclosed to both parties and both parties agree to the terms by adding their signatures thereto. And that good credit, honest credibility, is the most important thing that you have. Well, a valid contract has 5 parts. 1, offer, acceptance. 3, consideration. 4, signatures of all parties to the contract. And 5, full disclosure and mutual understanding of the terms. Only the parties that sign the contract can enforce the contract. What's more, a lawyer cannot settle any dispute that may arise from a contract without both parties' consent. The Creator created man with the unalienable right to govern himself and to form a government. Man gave government the right to form corporations. As man has no right to rule his creator, God, a government has no right to rule its creator, man. A government can only govern what it creates. Government created a legal fiction to rule by giving it a corporate name and assuming man to be that a legal fiction and writing his name in all capital letters with the middle name only an initial or not at all. The proper name for a living soul is written in upper and lower case letters, the first and middle name being the sovereign name and the last name being the family name. The real name for a living soul is I, me, my, or myself. Government is only a piece of paper, being a creation of mankind. As the government, being a piece of paper, could only create a corporation, which in itself is not able to sign a lawful contract with a living soul. All corporations must have someone to speak for them, and the government came up with a solution, the lawyer, who has been appointed to speak for all corporations in the courts which they have created. The government then devised an alternate to the lawful contract called the unilateral contract or one-signature contract. Their own description of the unilateral contract says that they were probably written up by a lawyer or a group of lawyers to commit fraud with the intent to extort monies from the signers. The lawful problem with these contracts, aside from the fact that they only have the signature of one party to the contract, is that they have many hidden traps about which the party is unaware. In many cases, such as bank contracts or signatures for checking purposes, the contract is never shown to the depositor. All contracts pertaining to corporations signed by a one-party participant are fraud from their conception and are used to extort monies from the people. They cannot be enforced except with our permission or consent by assent. From the beginning, men have the right to contract with whomever or for whatever they so choose. The government set their court system apart from the Constitution and its people, and then invites the people to contract with their court system under their foreign jurisdiction flag to allow them to settle their disputes. Since a person is to the government as a corporation, they treat any living soul who contracts with their court as a corporation as well, and as a legal person and a slave or debtor which cannot speak for itself. The first thought that enters the minds of people when they receive a letter from a lawyer saying, "You have been sued," is to hire another lawyer to settle the dispute between the two corporations in their corporate court. The judge protects the lawyers, and they, in turn, protect the court, for they are officers of the court. The system is called a legal system, meaning that what they are doing is legal. Legal simply meaning with your consent. After they gain your consent, the system then becomes lawful with your consent for whatever they choose to do to you. Law or lawfulness is constitutional in subject matter, for no law can be enacted or is supposed to be without an enabling clause from the Constitution of the state or for the United States of America. The court does not have a contract with a party until the party gives the judge his or her name. Until that time, the judge is simply an actor in a black robe. Until then, the court is trying to get the party to contract with it under their foreign jurisdiction flag. Since judges do not file their oath of office into their courtroom, they act under administrative law as however they may choose. The laws passed since 1926 have all been signed by the President of the Bar, the British accredited regency of the state of New York, bringing all laws under the bar as nothing more than bar codes, rules, regulations, statutes, and procedures for the corporations to follow. The only way you have to make the judge uphold his oath is to file his oath into the case and restrict him to the type of law that you want to follow. There are 7 demands for discovery to demand of all lawyers. 1. Produce the legislative act and its implementing regulations that precipitated this cause. 2. Produce the legislative act that created the office of lawyer, attorney, counselor, esquire. Give me the address of his office where I may go and get a license to practice law. 3. Produce a copy of your oath of office as an officer of the court and where you filed it into the public record. 4. Produce the contract signed by myself, proper name of the living soul, and you, name of the lawyer, in which I agreed to give up my constitutional rights. 5. Give me your name, address, and phone number. 6. Give me your bond number and your bonding company name, address, and location. 7. Send me an acknowledgement that you understand that you have perjured your oath of office and are committing constructive treason against the Constitution for the United States of America, the state of Maine, and the American peace flag. Under this system of consent, a living soul never has to accept the ruling of the court, but they must object at all times to the action being taken. All persons spending time in prison were sent there by their own words. Example: Judge, did you receive a fair trial? Answer: yes, the party is just being railroaded. Did your lawyer fight hard for you? Answer: yes. Do you feel that 12 years is a reasonable sentence? Yes. You just sentenced yourself to prison. This is aided and abetted by the party's lawyer, who has just told him to be nice to the judge in the sentence phase of his trial, and tells the party that the judge is probably going to give him a 12-year sentence instead of the 50-year sentence he could get. The other part of the problem is with the laws in today's court, or the total lack of laws. The charge and intent are combined in one charge, so you cannot plead innocent. You must plead guilty, not guilty, or no contest, thereby giving the court jurisdiction over the case. All the courts have been lumped together into one court, administrative/admiralty civil, contract commerce. With the taking of your plea, you go administratively under any law they want to use to convict you. In order for a law to be construed as law, it must have an enacting clause from the source the law came from, i.e., king, legislature, etc. All laws proceeding from the state legislatures must have an enacting clause, be it enacted by the legislature of the state of Maine. A legislature can only introduce a bill. It cannot introduce a law. The bill must go through, be approved unanimously by the House, signed by the leader of the House, be approved by the Senate, signed by the leader of the Senate, approved and signed by the governor, and then the bill becomes law. Now it is checked against the Constitution to find the enabling clause from which it was written. If the Constitution does not allow for the law, then it is void from its inception. Have you ever heard that a party can challenge the enacting part of the law or the subject matter jurisdiction of the matter he or she is being tried for violating at any time during the trial or even upon conviction while in prison. Usually, it is not a law that a party is being tried for breaking, but a code, rule, regulation, or breach of contract. The proper response to "you have been sued" is the redemption process, or rejection, returning their contract unsigned within 3 days in full accord with the truth in lending. Never let an attorney or lawyer send you any document without accepting it for value or rejecting and returning it without signature in 3 days in full accord with truth in lending. They may say something to you in their first letter, and you may think it is harmless. A rattlesnake seems harmless and makes a pretty noise, but it is deadly when it strikes. Have you ever heard the phrase, "you don't need to respond"? Do not believe it. Respond with the redemption process or reject and return it without signature in 3 days, in full accord with truth in lending. Don't contract with third parties. Tell them to get lost. Tell them that they are fired. We now understand that the government gains power of attorney over us when we are born, and they take our birth certificates and make negotiable instruments out of them. We now know that through the Social Security Administration and the issuance of SN, we are recorded as a trust, and the living soul is made the trustee instead of the executor that you should be of the strawman trust they created. We now have our own power of attorney, in fact, and we now know which form to fill out for taxes. Already we have one. 10. Redemption timeline. There have been so many papers written about the redemption process, and yet there seems to be a lack of understanding of the basic concepts. Redemption is the initial path taken by people who know they are free but see no hope in the judicial system as it is practiced today. It is vitally important to understand how the people in the government turned our lives upside down and have made us believe that we are subject to them, when in reality, they are subject to us. Every being is part and parcel of we the people. Key points. 1. In 1871, the federal government formed itself into a corporation and pulled itself out from under the Constitution. 2. In 1913, the Federal Reserve central banks were created. 3. In 1933, President Roosevelt rewrote and reinstituted Trading with the Enemies Act of 1917. This applies only to 14th Amendment citizens of the federal United States. 4. In 1933, President Roosevelt took the gold away from the people, although they were not required to give it away, thereby leaving the people without money for paying their debts. 5. In 1933, President Roosevelt passed H.J.R. 192 of June 5, 1933. Simply put, since the government had taken the gold and the people had no money, the government would pay the debts for the people, dollar for dollar, thereby giving the people unlimited credit. 6. In 1938, Erie Railroad versus Tompkins made contracts the rule of law in our courts. 7. In 1946, we lost our government and courts through the Administrative Procedures Act. And for 8. In 1965, silver was taken away as a means for paying debt. The UCC became the supreme law for America concerning the banking system, and the courts were pulled together in administrative, admiral, civil, contract or commerce corporation, and the act and intent were brought together, thereby taking away any plea of innocent. You have to now prove there was no intent. Guilty until proven innocent, changing the often quoted phrase, "you are innocent until proven guilty." 11. General instructions. Some of this information is simply personal opinion and preference, so please study the issues and make up your own mind about everything you choose to do. 1. Answer immediately your correspondence. Do not put your paperwork off. 2. Never answer a third party. Respond with a rejection of contract offer. I reject your offer of contract, telling him and all of his heirs, agents and assigns that they are third parties and to get out of your commercial affairs. 3. Always send the rejected offers of contract back to the entity that sent them to you, return to sender, and then copy anyone else involved, i.e., if you get a summons complaint taped to your front door and it doesn't say where it came from, it probably came from the sheriff. Reject it and send it back to the sheriff via certified or registered mail. Then copy the court and the other party to the summons, usually a lawyer. If you get it in the mail, make sure you look at the return address because sometimes a service company sends it to you. It must be rejected and sent back to the service company, returned to sender, and then all other parties copied on it. 4. Always remember they are after subject matter jurisdiction. 5. The only thing involved in any controversy or court case is about jurisdiction. Number 6. Subject matter jurisdiction, SMJ, is the same as challenging the court's jurisdiction, but in a nicer way. Instead of telling the judge that the court doesn't have jurisdiction over you, you are telling the court that they don't have jurisdiction over the subject matter to hear the case. This gives them an out. SMJ is over you, the living person, and that is why they never have it. They must have firsthand knowledge and be a party to your contract, but they never do nor are. Don't argue the charge, the amount, or anything other than SMJ because when you start to argue the issues, you grant SMJ. Maxim, arguments are for fools. 7. Subject matter jurisdiction can only be gained with your permission by consent or assent. Warning, making a plea grants consent. 8. Everything they do against us in court is by affidavit and usually without any notice to us. You must check the court file daily to see if anyone has placed an affidavit against you, and you must rebut every affidavit with an affidavit point by point. We will be lawful, though, and give grace and notice with our affidavits. So if you rebut an affidavit or generate an affidavit, always send it to the person it is against. Copy the court clerk if it is involving a court case, giving them personal notice and a grace period to rebut it. You must include a rebuttal address for them to send a rebuttal to, either your address or a notary's address. I suspect that the notary is the one who should receive the rebuttal. Number 9, what we are finding out is that even though we do an affidavit into court challenging subject matter jurisdiction, that unless you go into the court at the appointed court time and stand up for the affidavit, the judge will put a default judgment against you. We have added a cease and desist order to our affidavits, which may take care of having to go into court, but this has not yet been established. Some students will not use the zip code as it is for federal jurisdictions only, creates jurisdiction, and sets up a pattern that you are a federal citizen. Sample address is as follows: Jack Rabbit Patriot Non-Domestic CO 123 Bayview Drive, Portland, Maine 04105, zip code in brackets, OK. Also, only use a stamp because that doesn't create a jurisdictional problem, but their stamp machine may. Rule 11. You can take jurisdiction of all letters you send, return receipt request cards, envelopes, etc., by signing your autograph in red ink at the bottom right on both the front and the back side of the pages, cards, envelope, etc., and make sure you write it where no one else can sneak a number or mark past it to the right or underneath your autograph. 12. With the autograph is used instead of signature under the living man's name because a signature is only the sign of someone's name/authority. It is not the real name. Do you ever hear anyone chasing a movie star or famous sports hero saying, "Hey, give me your signature"? No, it's always, "Can I have your autograph?" So 13. With the copy claim is used because anything you copyright/copy claim is protected from being used against you in a court of law unless you introduce it as evidence yourself. Please read through your documents carefully to ensure that all names, addresses, or other information has what you are sending out. You are responsible for your documents, no one else. 14. In a negative averment, list your town and any town of anyone who is coming against you. For instance, if a judge in another town is sending you a summons, then list his town and state too. 15. In a negative averment, it might be wise to handwrite the following statement in red ink. I am not a fictional limited entity. I am a natural-born child of the Creator. I am not a surety or accommodation party for any fictitious person. Some people choose to use the Creator's Hebrew name that he tells Moses to tell the Israelites because they believe it carries the weight of truth. Obviously, this will be a personal religious conviction. Any and all of this information can be changed to suit your particular beliefs or situation. This is your information, not mine, so do as you see fit. Just include that. I am not a fictional limited liability entity, otherwise known as a corporation. 12. Proverbs of Law 1. You cannot be bound to a contract if you were hoodwinked. 2. It is impossible for you to be in a contract with the government, but no fraud exists when you're not contesting your rights. 3. Produce your proof of claim for what you're alleging that I cannot do, other than doing harm. 4. Your rights have a price attached to them. You might send a fee schedule and notice that any of your rights is worth $1 million, non-negotiable. 5. My offers are non-negotiable. 6. Think of your domain as a car lot where your office person is located, and your rights as the cars sitting there for sale, with advance notice that violating any of your rights is worth $1 million. Whether they buy or not is their choice. These are your rules for your domain. 7. It's your choice to violate my rights. 8. It's my jurisdiction. It's my domain as long as I do no harm. 9. Send me evidence of what I cannot do as long as I do no harm. 10. I am the executor and beneficiary of my estate, and I'm telling the trustees what my rights are worth. 11. Assuming liability. He who assumes the liability is in the seat of power because he is the one who is liable. He's the one who dictates orders to his trustees. He's assuming the risk they are a limited liability corporation. 12. When you go into their game with full liability, they never can win. They're limited liability, and you are not. 13. Yes, I am that name. I accept full liability. 14. It's not about your name. It's about who you are in their game. What position are you playing in their game? What role are you playing? 15. If you're man, you're the executor and beneficiary of your estate. 16. A trust has been created in your name via a trust agreement under trust law. 17. A hearing is being conducted for a legal person in whom you have an interest. 18. Think of the corporate structure of a trust. 3 parties to a trust. The director or board of directors, the employees, the trustees who perform the functions of government, and the shareholders, the beneficiaries, who appoint and control the directors. 19. The shareholders can remove the directors because equity is king. 20. A corporation is a trust agreement. Therefore, the United States Inc. is a corporate trust. 21. My parents invested my abilities in the corporate United States, making me a beneficiary of the trust. 22. Anytime I perform a function of government, I'm acting as a government employee, a government trustee who takes orders from the state. 23. I own all the equity in the trust, all the credit in the corporate United States. 24. I am the director who directs the trustees of the trust and who appoints and directs the Congress of the corporate United States. 25. I own all the equity in the trust. I am the director of the trust. I set the policy of the trust. 26. Their statutes have no effect on my beneficiary, my legal person's strawman. 27. It's my job to protect my investment in the trust, my investment in the corporate United States. 28. All I need to do is state my position in the game. I can confirm my position in the corporate United States. 29. I am a grantor, shareholder, beneficiary of the corporate United States Trust. I can appoint the board of directors of the trust, who set the policy of the trust, and who aid to direct the actions of its trustees for my benefit according to the Constitution for the United States of America and the Bill of Rights. 30. Are you challenging my claim that I am the director of the legal person? 31. My signature created the corporation. 32. It's a trust agreement between us and the government that made it an entity. 33. I put everything into the trust. I don't remember at that point signing anything that I was going to obey government statutes, so nothing outside applies to my corporation. 34. I'm here regarding the matter for my legal person. My name is President and CEO for that corporation. 35. Establish your title at the head of the documents you write or at the beginning of the trial. 36. Your name is your title. In other words, your title is your name. 37. I am the chairman of my board and only I call board meetings. 38. I am the sole shareholder of my trust who appointed me as the director of my estate. 39. The matter before the court is the hearing for the legal person. I am the president, director / administrator agent for that legal person. Which one do you want me to be? 40. Courtrooms are platforms for government. 41. You're establishing your authority on the record with that court. 42. All you have to be is the sole beneficiary to be fully in control. 43. The shareholder directs the beneficiary who appoints the director who directs the public employees to act according to the Constitution or the charter of the trust. 44. Statutes apply only to public employees. 45. If you're not performing a function of government, they can't enforce an income tax upon you. The Income Tax Title 26 only applies to government employees. 46. You're supposed to perform a duty, and they're supposed to perform a duty, or else mutual consideration does not exist. 47. If you don't agree with me, you have 21 days to respond with proof of claim to the contrary. 48. Are you claiming that I am an employee required to obey the statutes of the United States? 49. Is there something you're claiming I can't do other than create harm? 50. He's going to the penalty box because he broke one of the rules of the game when he was playing hockey. 51. If you agree to be an employee, you must abide by employee rules, for if you don't, you get punished. 52. If you want to give notice to the government first thing. 53. If you have a business relationship with government, establish your role at the outset to avoid presumptions. 54. The birth certificate is proof that I am a shareholder in the corporate United States. It's the receipt for my trust foundation investment. Shareholders receive dividends. 55. I own all the equity in that thing, in John Doe. 56. If you're disputing that fact, feel free to let me know. Arguments are for fools. 57. Shareholders appoint directors and can remove them for good cause. 58. Clarify the game before problems arise. Send notice from John Doe as director/administrator. 59. Who am I? I am man, director/administrator. 60. Are you looking for the legal person? 61. Presumptions are not facts until both parties agree. 62. Send notice of default, then a certificate of default. You're the director in charge. 63. The legal person has been charged with such and such by the plaintiff. Overruled, signed, director. 64. Establish who you are beforehand. 65. The birth certificate is the true seat of power. It's proof of your shareholder investment in the corporate United States. 66. File that proof in the court record. 67. The court is the boardroom of the corporate United States. 68. It's not a fact until both parties agree. 69. If the judge issues an order as an employee of the state, who can overrule him? Yes, the director in charge. 70. The legal person has been charged with such and such. Overruled, signed, director. 71. There's no injured party in a statutory offense. 72. I'm the director of my legal person. 73. The corporation has asked for this amount of money. Good, tell them to pay it. It's over at this point. 74. Preemptively contract them and establish the rules. 75. The court is the upper management of the corporate premise. 76. You're on the board of directors of the corporate United States. Claim your title, establish who you are. 77. Let them know who you are before you appear. You can't establish your identity without letting them know who you are. 78. Establish the power structure in mind and in court. 79. Contact the government's attorney general and assert your rights and stop driving with a license plate at all. 80. They need your My tax exemption. 81. Put a plate on that has some identifying marks so when they run the plate they know that it is you and you're not to be mortgaged. 82. Notice them with a fee schedule. If you see the number and you pull me over, it costs this much. 83. You have no reason to pull me over. I'm not performing a function of government. I'm not a government agent or employee. 84. No one owns title to the legal person. 85. My parents gifted my abilities to the U.S. corporate trust. 86. John Doe is the grantor, shareholder, beneficiary of his trust. 87. John Doe is the executor administrator of his trust. 88. Govt employees are the administrative trustees of my trust. Corporate law mirrors trust law. 90. Shareholders appoint directors. Directors set policy. Directors tell the employees what to do. Directors give orders to the employees, which they must obey to avoid breach of trust. 91. Employees carry out the director's orders. 92. I'm a shareholder in the corporate United States Trust. Shareholders receive dividends. 93. Trust law, corporate law equals the Holy Trinity. 94. The owner of the equity controls. 95. Appoint yourself as the director. Only two roles left, government and government employees. 96. Everybody is an agent for the legal person according to the role he plays. 97. The Constitution only applies to the government. 98. Statutes and regulations only apply to government residents and employees. 99. My birth certificate has the government's signature on it. Therefore, the government owes an obligation to me. Shareholders receive dividends. 100. Applications for benefits create public servants with titles. 101. Public servants are taxpayers who owe taxes. 102. Complaints are made against public servants. 102. SSNs are optional for non-interest-bearing accounts. 103. Statutes and regulations only apply to government employees. 102. If I'm assuming liability for the actions of someone else, I have a right to control what he does. 103. If you're assuming full liability for your actions and you never intentionally cause harm, you can never be held accountable for what you might accidentally do. 104. Unintentionally causing harm is not causing harm according to law because it was not intentional. It just happened, so you're not actually liable. Intent is everything in law. 105. They never reply to affidavits because it would be perjury on their part. They can't prove anything. They never try to prove anything. 106. You have to enter a plea in their jurisdiction for a hearing to proceed. 107. Any ID from the government is not good because it identifies you as having applied for a benefit, making you a public servant, where the government assumes all liability for your actions and therefore has the right to control you. 108. It's not their responsibility to teach you who you are. 109. Remove presumptions, establish the terms. 110. You never have to make a plea. 111. There's no reason to go to court until you win. 112. Send it into the courthouse in writing with a motion to dismiss long before you have to show up before the court. Let them know you're not going to come, right? I believe that default judgment is for public servants, and I haven't seen any evidence that proves that I am a public servant. 113. I have not seen any facts, nor have I been provided with any evidence that I am a public servant, and I believe that no such evidence exists. Send this into the court with a motion to dismiss. 114. You are not compelled to enter a plea. 115. A trial cannot commence until a plea has been made. No plea, no trial. 116. I don't allow you to enter a plea for me. You can't legislate from the bench. I will not enter a plea until I see a claim made against me. Everything else is irrelevant. 117. Default judgment is not a court of record. 118. Transcripts are not a matter of public record. File transcripts in the court record. Anything of record is in common law jurisdiction. 119. Get a certified copy of what you submit to the court in return. 120. If it's boxed off, it's not part of the document. 121. The court can't hear a jurisdictional challenge. No one judge can rule on his own cause. 122. Make your case a court of record by swearing out an affidavit and filing it with the court. Then it's up to the state to rebut it, point by point. 123. Who brought the complaint to the court? The state. 124. The state said we're disobeying orders, so we address the state first before time for court. 125. Prove that I was acting as an agent of government at the time of the complaint. 126. Just because you showed a driver's license doesn't prove you were acting in that capacity at that time. 127. I can make a statement about what I was doing at the time. This I can prove. All else is presumption. 128. They're a private corporation. 129. Never talk with them without being charged. You have a right to remain silent. Anything you may say can be used against you in a court of law. 130. If it is not a matter of public record, it never happened. 131. I'm here regarding that matter and I'm convening a court of record. 132. Deal with the state before you go into a hearing. 133. This document is a matter of public record, header of document. 134. Are you claiming that I was a public servant when the complaint was made? 135. Produce the payroll record to show that I was a public servant performing a function of government. 136. Do no harm. All else is okay. 137. Government statutes apply only to government agents. 138. Unless you're a government servant, you can't be charged with a statutory offense. 139. My birth certificate makes me the director of my legal person estate. 140. Only man can create value. 141. Corporate law is trust law as well. 142. Equity in commerce is king. 43. I don't believe that I am a public servant and haven't been shown any evidence supporting that presumption, and I believe that no such evidence exists. 44. Send it into the court. File it with a motion to dismiss the charge. 145. Never go to court unless you've won, and only for default judgment. 146. If no timely rebuttal is received, it is agreed that you agree with me. 147. It is my belief that I own by property in fee simple as defined in Black's Law Dictionary, not as joint tenant in common. 148. Your act does not apply to me. 149. Facts are agreements of the parties. 150. Government is not my enemy unless they try to force something upon me. 151. Establish a fee schedule. 152. We are all peace officers. 153. Identify yourself your way. 154. No plate, no jurisdiction to tow. 155. Don't use statutes to defend yourself. 56. Watch the words you use, i.e. aboriginal, unclean, abnormal, original equals clean, normal. Citizenship on the citizen's ship. 157. Seldom verbally state your name. Write it down or spell it out instead. 158. Is there something you're claiming I can't do other than it cause harm? 159. Write a default certificate and file it into the record. 160. Remove the presumptions at the start. 161. It's impossible for anyone else to assume liability for you. 162. Don't play the word definition game. 163. You're in the private domain. 164. I was not performing a function of government at the time, although I have a license to do so if I wish. 165. They're my roads, not the government's roads. 166. I am the public. 167. The government only has jurisdiction over commercial performers when performing a function of government. 168. I have a license and I am not on duty in that regard. 169. You applied for that license to perform a function of government. 170. The government only has jurisdiction over commerce. 171. Give notice. Give notice. Give notice. Nobody likes to be surprised. 172. My plate is evidence of a fee schedule in place. 173. I'm going to be accessing the public roads with my flag on my vessel. 174. The Trespass Act. Private property equals my bodies, my rights. 175. Contract with the DOT. 176. Tag text. dr.me, not for hire. Private property. 177. Give 10 days, 3 days to think it over, plus 3 days to deny, plus 3 days for the mail, plus 1 day of grace equals 10 days. 178, default, then send notice of default, then file copies in the court. 179, don't go to court unless you have already won. 180, $1 million is not excessive damages for an accidental death charge. 181, we extend the privilege of using the public roads to the foreign corporation to operate on our soil. 82, to the public servant officer, did you observe me breaching the peace? Are you claiming that I am a public servant? And 83. I'm sorry, but I don't have any ID showing that I am an agent of the government. 184. Am I under arrest? Am I free to go? Do you have a warrant for my arrest? Arrest me or let me go. 185. I don't know who you are without knowing your badge, number, and name. 186. Freedom equals responsibility. 187. He who does not deny admits. 188. Government is merchant's law. 189. The contract makes the law between parties. 190. In a republic, citizens elect officers to manage public servants for the benefit of the citizens. 191. In a corporation, shareholders elect directors to direct employees for the benefit of corporate shareholders. 192. In a trust, grantors appoint executors to manage trustees for the benefit of the grantors. 193. In the court, the corporation appoints judges to sustain or dismiss charges against the accused for the benefit of the state. The 10 maxims of commercial law, 10 maxims of law. 1. Exodus chapter 20, verse 15, Leviticus chapter 19, verse 13, Matthew chapter 10, verse 10, Luke chapter 10, verse 7, 2 Timothy chapter 2, verse 6. 2. God's law, natural and moral law. Exodus chapter 21, verses 23 through 25, Leviticus chapter 24, verses 17 through 21. Deuteronomy chapter 1, verse 17 and chapter 19, verse 21. Matthew chapter 22, verse 36 through 40. Luke chapter 10, verse 17. Colossians chapter 3, verse 25. 3. Exodus chapter 20, verse 16, Psalms chapter 117, verse 2, John chapter 8, verse 32, 2 Corinthians chapter 13, verse 8, 4, Leviticus chapter 5, verse 4 through 5, Leviticus chapter 6, verse 3 through 5, Leviticus chapter 19, verses 11 through 13, Numbers chapter 30, verse 2, Matthew chapter 5, verse 33, James chapter 5, verse 12, 5, 1 Peter chapter 1, verse 25, Hebrew chapter 6, verse 13 through 15, 6, Hebrews chapter 6, verse 16 through 17, 7, Hebrews chapter 4, verse 16, Philippians chapter 4, verse 6, Ephesians chapter 6, verse 19 through 21, 8, Book of Job, Matthew chapter 10, verse 22, 9, no willingness to sacrifice equals no liability, responsibility, authority, or measure of conviction, nothing ventured, nothing gained. 10, Genesis verse 2 through 3, Matthew 4, Revelation. 10 maxims of law. 1, a workman is worthy of his hire. 2, all men are equal under the law. 3, in commerce truth is sovereign. 4, truth is expressed in the form of an affidavit. 5, an unrebutted affidavit stands as truth in commerce. 6, an unrebutted affidavit becomes judgment in commerce. 7, a matter must be expressed to be resolved. 8, he who leaves the field of battle first loses by default. 9, sacrifice is the measure of credibility. 10, a lien or claim can be satisfied only through rebuttal, by counter-affidavit, point by point, resolution by jury, or payment or performance of the claim. Thank you for listening to Part 2 of Be the One to Execute Your Trust by David Robinson. All information in this book is credited to the author and only the author. See you on Part 3.